We are going to have a chat with Carol Van Cleef now. Carol will be joining us virtually, but I'm going to be asking her some questions. We're going to talk about a path forward for navigating this increasingly complicated regulatory maze that is the US regulatory system. I'm super excited to have Carol here. Carol is a highly respected attorney specializing in AML and compliance in cryptocurrency, but I'd love it if you provided us with a bigger introduction to yourself, Carol.
Well, thanks so much. I'm sorry that I can't be with you today in person. Prague's one of my favorite cities, and I wish I were there. But I do want to say thank you for the opportunity to talk today. And I'll tell you, that was a tough act to follow with our last speaker. He raised a lot of very provocative issues. In terms of my background, I've been in crypto before. I've been in digital currencies before crypto, having really gotten 2 feet in, beginning in 2008, in sort of the cleanup of federal prosecution of a gold-backed digital currency system. Over the next several years, I learned many fundamental premises that have really underlied a lot of the conversations, a lot of the public policy debates, and so on, that we've been having over the last now 10, 12 years. Again, I appreciate being here today and would welcome further questions, but I thought what I would do is, sort of the concept of finding our way through this maze. Our last speaker laid out a lot of the complications, a lot of the concerns, fears that the crypto space has encountered. One of the biggest issues we hear in crypto in the US is that we do regulation by enforcement. And I'm going to be a little bit controversial today and say that I think that's overused and abused, that phrase. It is in large part a creation of crypto Twitter. But in a lot of ways, it's code for saying, I want to do what I want to do, and the regulator shouldn't be telling me what I should do, especially on the backside of if I did it wrong. And that's not really the way the system works in the United States. We really operate off of an honor code of sorts, that we give people a lot of flexibility, and we gave many people in the crypto space a lot of flexibility for a lot of years. It's only when something goes wrong that suddenly people start to focus on the issues. And you heard some comments about Operation Choke Point before, is that was really an outgrowth of the fact that we had people in the system who were not monitoring and watching and seeing what kind of criminal abuse was happening and taking the steps necessary to cut that criminal abuse down at the time. When I know regulation by enforcement comes up many times in the securities arena, and in fact, as I'm speaking now, the SEC Chairman Gensler is testifying before Congress and getting grilled on a number of issues, not the least of which is crypto. But what I can say is that what the SEC has been doing largely has been following through on a set of laws and regulations that it's had in effect for many years. And it has intermittently provided a fair amount of guidance to the crypto space, but many people in the crypto space have not wanted to go and ask the questions of the SEC, in part because it costs money if you really want to present your case appropriately. It also can take time. And that's, in this space, time is an enemy in many ways. But for those of us who are used to sort of following a little bit more by that guidebook of, ask the questions, get the answers, and then you've got the protection on the backside, we could see what was going to happen with the ICOs in 2017. That was a very easy situation to predict. We've seen it with the DAOs. We are now seeing it in the NFT space. These are things that, with a little bit of a different perspective, could be handled in a different way. And I know that's going to be highly controversial, but I've been working on these kinds of issues and trying to find these paths forward for many years. So I guess if you're not going to necessarily take the time, have the money to make the effort to clarify what the business model looks like going in, I do have some suggestions for you. in navigating the U.S., especially if your business model, if what you're writing, your code, in any way is expected to touch U.S. residents, or in fact, you might end up operating, having operations in the U.S. I'll start by saying that we regulate by function. I think many people understand that by now. If it's a security, or if regulators think it's a security, then what we're dealing with is looking at the securities laws. But if we've got a currency and we think that we've got a currency, then there's a whole different set of laws and regulations that apply. So that's number one, is looking at function. The second is looking at where you're going to be, the types of customers you're going to be interacting with, in what kinds of jurisdictions. We do have a system of dual regulation in the US. We have regulation at the state level, in the securities area, in the currency area, and we have regulation at the federal level. So you have to understand, are you playing in one state? Are you playing in multiple states? If you decide you want to touch New York residents, we know that's a different ballgame altogether. But I think the most important piece for you as you're going through this process is you need to have people at the table with you that really understand the laws and the regulations. And I know there are a lot of people who will tell you, oh, I understand it, I understand it. And in fact, the gold-backed digital currency system that I mentioned earlier, back in 2008, went to a lawyer that they thought, could answer all the questions. Sorry about that. I have my backup here, so hopefully we didn't lose anything in the transition here. But back to the comment that in 2008, this gold-backed digital currency system went to a lawyer who thought that the lawyer could answer questions for them on what their system looked like. And in fact, the lawyers missed some very fundamental issues. The next question is, after you understand what your functions, are you more like a security? Are you more like a currency? How is it functioning in the real world? You need to look at the issues around who can use it and how they can use it. And this is something that early stage entrepreneurs in particular miss frequently, is that no one thinks that criminals are ever going to use the system that they're creating. Tornado Cash, did they ever think that the North Korean government was going to use the system, the Tornado Cash protocol, smart contracts, for purposes of laundering the proceeds of ransomware hacks and other hacks, and using it for weapons of mass destruction? Maybe they did, and maybe it was very intentional, and that takes us into another world. But if you go through the process of trying to figure out what your model, how it can be used by different people for different things, and particularly look at how it can be used by criminals. From there, you do need to consider, we're unfortunately moving in a world that I guess the best of the early days of crypto, in the fact that there was anonymity in transactional activity. We are definitely moving away from that, where if crypto is going to move mainstream. And so you will need to consider what kinds of KYC, know your customer identification, do you put into place? At the very least, depending upon what your system looks like, you're going to look at, and I said at the very least, IP protocols, to have a sense as to whether you're doing business with someone who may in fact be in a sanctioned country. We just saw the US government take a major action yesterday based on IP protocols. So that's getting a better sense of who your customer is going to protect you. And that's what you need to be thinking about, is that you're in a different world than we were in 2013. Law enforcement community understands much better crypto. There was an interesting tweet that's been circulating in the last day or so by someone who ended up being stopped at an airport, taken aside into a holding room because law enforcement had tracked his IP address through I believe, either Google or Amazon, if I recall correctly, but had gone to great lengths and had actually identified this as the person who may in fact be involved in a major hack that had recently occurred. So law enforcement has many tools available to them. It's sort of a case that you can run, but you can't hide anymore. And we're moving into a very different kind of a world. So not only do you need to have a better understanding of who your customer is, but you also need to be monitoring the kind of activity that is moving through your business model. And I say that because you may have a business model that does something very different from someone else's business model, but each one of you needs to work through an analysis of how your business model could in fact be used or abused by criminals. Because if you don't do it, then at least in the United States, but in a number of other jurisdictions, we have the concept of willful blindness. And what that means is that if you could have known, but didn't ask the questions and didn't take the steps that you should have to protect your system from being used or abused, that you could be implicated in that activity. And I'm assuming that that's not a place that most of us want to be. I would say almost all of us want to be. So again, I would certainly caution you on that. And then something else we've seen in the US recently is we're seeing increased focus on consumer protection at a more sort of old-fashioned financial services consumer protection focus, one of which is price. You know, how kinds of charges are associated with the system that you're developing and the kind of money that you're taking off the table related to the business that you're operating. We have a set of laws, both at the federal and the state level, that deal with what we call unfair and deceptive practices. And if you're deemed to be charging too much in an area, that could be an unfair practice and could subject you to fines. That could again happen on the federal level or at the state level. And we've seen some crypto firms being subjected to fines related to that. Can be very costly, especially for early stage companies. So those are a few thoughts. I don't know if there are any audience questions at this point.
Yeah.
If not, I can then turn to some sort of more broader geopolitical issues.
Sure, I had two questions, but also there's someone in the audience that has a question right up front. We have about 5 minutes left.
Hi, what did eGold and the other companies of the late 1990s do wrong? I was tangentially involved in that situation. This is Ryan Lackey, and very happy not to have been too closely involved in that.
Well, it was in fact eGold that I was involved with. I was hired on the backside of the federal prosecution. I spent a long time looking and trying to understand what went wrong there, because there's actually many very redeeming points of the system. And there was a lot of things that they were doing and they had learned along the way to do to protect themselves in the way that we're talking about it. At the end of the day, not to go too far into the weeds, but when they entered into a plea agreement with the US government, and they pled out to federal money laundering charges, which is a very steep penalty. And if one wants to move forward, especially in these kinds of businesses, having that kind of a plea is not going to be helpful on a long-term basis. What the judge at sentencing, the US government, and this is worth telling the story, is that sentencing, the US government asked for the founder, Dr. Douglas Jackson, to be imprisoned for 10 years. At the end of the sentencing proceedings, he was subjected to an ankle bracelet, home detention for 6 months, plus community service, and parole on an ongoing basis. He had to check in every so often. But there's a big difference between what the government wanted and what the judge gave. And the judge, in her sentencing memoranda, which she had to prepare because she deviated so significantly from federal guidelines, she said she didn't believe the system was illegal. She didn't believe that they had illegal intent, and that's a huge issue. But she said at the end of the day, they had bad legal advice. And that's really what it came down to, is that they had lawyers who did not really understand the interplay of the laws and regulations in the US. And we saw our last speaker talk about the Bank Secrecy Act, and this I'll deviate from the rest of the story because this is a very important point. The Bank Secrecy Act is a law that went into place more than 50 years ago now, and it requires record-keeping and recording by companies that are subject to it. In the eGold case, the lawyers focused on whether eGold, this gold-backed digital currency system, was really subject to that law, because there was nothing in the statute that said, oh, a gold-backed digital currency system, a digital currency system, is subject to regulation under this law. Apparently, the government asked FinCEN for an interpretation. FinCEN didn't come out with an interpretation in a timely fashion, so the Department of Justice took it upon itself to interpret the law and say, yes, the Bank Secrecy Act applied. The lawyers here had made a 100% guarantee to the company that it was not a money service business, which the judge ultimately decided. And at the point the judge said, you are, they ended up folding their tent. Now, what the biggest mistake made by the lawyers here, and this is the hardest piece for the crypto space to understand, is that in the US, we also have another law, a federal criminal statute, that says that it's illegal to engage in money laundering, to aid and abet it, or be willfully blind. And remember, I mentioned the word willfully blind a minute ago. In that context, if you don't ask the questions, you don't get the answers, and you don't put some prophylactic things in place like KYC and transaction monitoring, you could be deemed willfully blind. And regardless of whether you're subject to the Bank Secrecy Act, you should be taking steps to protect yourself. And that's the biggest takeaway, I think, from the eGold case. In the case of Liberty Reserve, they were just plain out, engaged in crooked activity. And that was recognized by the fact that, and this is a 2013 case, that the CTO and the head of IT went to jail. Which is a real serious takeaway for coders, because we do have a precedent that if you're participating in writing code that is going to be used for inappropriate purposes, shall we say, that could lead to a federal indictment and conviction. Any other questions? Hopefully that was enough.
Thank you, Carol, and particularly, I'd like to thank on behalf of the audience. It's always useful when you're able to provide some pointers on how to proceed, and especially this, complex regulatory quagmire that some people think is the U.S. system. So thank you very much for joining us, even if it was, that we got to distill some of that information. So thank you, Carol.